So, today we're going to talk about money in politics.
Last week, the Supreme Court reversed a century of law that I believe will open the floodgates for special interests, including foreign corporations, to spend without limit in our elections. Including foreign corporations, to spend without limit. I don't think American elections should be bankrolled by America's most powerful interests, or worse, by foreign entities. They should be decided by the American people. And I'd urge Democrats and Republicans to pass a bill that helps correct some of these problems.
So that was Barack Obama's 2010 State of the Union in late January of 2010, a couple of weeks after the Supreme Court had handed down its Citizens United decision. And the clip went viral because of that playback of Social Justice Samuel Alito, who lip readers were debating whether he was saying, "You lie," or "not true," in the middle of Obama's speech. It was an unusual speech because normally presidents do not criticize the court during something like a State of the Union speech, and nor do members of the court respond to what the president says. And so it became a sort of emblematic of the tussles between the Obama administration and the much more conservative judiciary. Many people thought and think that Citizens United was a horrific decision that, as Obama said, opened the floodgates to corporate money in politics, making even more problematic the sorts of things identified in the book about dark money, which I put on the syllabus for today. I'm going to give you a somewhat different argument. I think that Citizens United is a symptom of a much different and much bigger problem. And so that reversing Citizens United would really be sort of taking a Band-Aid to a much bigger problem. And so our agenda is we're going to start off by noticing that there's a difference between the supply of money in politics and the demand for money. Almost everything you read about money in politics is about the supply. It's about the lobbyists. It's about the fat cats. It's about the people who spend money in order to work their way in politics, and that's why they're supplying it. Almost nobody talks about the demand side. Why is there so much desire for money in American politics, much more in American politics than in many other systems? And so in the last part of the lecture, I'm going to come to the demand side. For most of the lecture, I better focus on the supply side, as almost everybody does, but we should remember that it's only one piece of the equation. I'm going to begin by talking, before I get into the guts of the money in politics subject, I'm going to talk more generally about courts in American politics and separate out some myths from realities. Many people think that the idea of an independent judiciary with powers to review the constitutionality of legislation that comes out of the political branches is a great thing. If you look at the third and fourth waves of democracy around the world, which I'm going to be talking about on Thursday, the idea of a separation of powers is a big American export. It's often the feature of the U.S. Constitution that is most often copied in constitutions around the world. I'm going to start out by spending some time on myths and realities about the role of courts in American politics and more generally. Then we'll go into the history of the First Amendment since the 1976 decision, Buckley versus Valeo, where the modern world of money and speech really gets started. I'll pay some attention to the changing media context that all of this is going on in as we've evolved from the world I was describing in the last lecture, the world in which everybody watched the same evening news at 6:30, to the world of Twitter and blogging and people getting most of their news from places like Facebook. And then we will conclude by attending to the demand side, the much neglected demand side, which will become an important feature of my argument later in the course. So let's talk about courts in American politics, as my subtitle here is Myths and Realities. This is a picture of the Warren Court. And I put the Warren Court up there for a very particular reason, which is that the Warren Court was a massive outlier in American history. It was a massive outlier because it was an extremely progressive, to use the term that liberalism has been reinvented as in the last decade or so, possibly the most progressive court in American history. And it was remarkable, first and foremost, because Earl Warren, who was appointed by President Eisenhower in 1953, Eisenhower called it the worst damn fool mistake I ever made. He had been a conservative governor of, a Republican governor of California. He had been responsible for the internment of Japanese prisoners during World War II. He didn't have any signs that he was going to be a much different person than he turned out to be on the court. And so he presided over this era known as the Warren Court. And as you can see, actually, interesting, if you go down to the bottom of the slide there, you can see another one that Eisenhower pretty much got wrong. Eisenhower's appointees are in blue there. William Brennan also turned out to be a very liberal justice and didn't make Eisenhower very happy. But you can see that there were 4 holdovers in beige appointed by FDR. And so it turned out to be the case that for much of this period, the court was extremely liberal. And it's also the case, and maybe not so surprising when I make this point, that if you look at the academics who are champions of judicial review, the Lawrence Tribes, the Ronald Dworkins, the Owen Fisses of this world, they are people who came of age during the Warren Court. And many people thought that this was a sort of secular development, that the court, which had struck down, this Warren Court, which had struck down a lot of racist and racist legislation and legislation that had been harmful to poor people, was sort of a new normal, a wave of the future, if you like. And after Warren was replaced by Warren Burger, and we started to get more conservative drifts of the court, you could often read, for instance, in the New York Review of Books, you could read articles by people like Dworkin attacking what was happening to the court as though they were undoing the new normal, and that this is a terrible thing and we just needed to get over this and things would snap back. So there was in what retrospect is quite a lot of denial about what was actually happening. But just to give a sense of how liberal the Warren Court was, this is the court that was responsible for the decisions in Brown versus Board of Education, 1954, and then the follow-up decision the following year that said separate but equal cannot stand. This is the court that in Baker versus Carr in 1962, and a subsequent case 2 years later, said the court can get involved in redistricting cases, that this is not a political question that they have to keep out of. And then they ruled that districts have to be more or less equal in size, population size, which was a way of limiting the disenfranchisement of urban voters. This is a court which in Mapp versus Ohio said that unreasonable searches and seizures would produce evidence that wouldn't be able to be used in court. This is the court that in 1963, Gideon versus Wainwright, said that indigent defendants would have a right to an attorney appointed by the government if they couldn't pay for one themselves. This is the court that in New York Times versus Sullivan said that if a public figure wants to accuse you of defamation, there's a very high standard. They have to find actual malice on your part. It's an extremely difficult thing to prove. So it was seen as a huge boon for the freedom of the press to act as the fourth branch of government, if you like, in criticizing public officials. This is the court that in 1965 adopted Griswold versus Connecticut, a decision that said that outlawing contraception in the state of Connecticut was illegal. It would become very important later because it became the building block for Roe versus Wade after that was actually the beginning of the Burger Court. But the logic came from Griswold versus Connecticut, which was that the idea, there was concept of privacy that the court affirmed in Griswold that would become the basis of the decision in Roe versus Wade in the following decade. This is the court that adopted Miranda versus Arizona. You've all heard about Miranda warnings. You have a right to remain silent. You have a right to have an attorney. And if the police violate those Miranda warnings, convictions will not stand. This is the court that adopted Loving versus Virginia, which outlawed anti-miscegenation laws against interracial marriage in many that had then prevailed in many states. So this is by no means an exhaustive list. Just to give you a flavor of the court, it was really seen as the vanguard of progressive change by many liberals and led, as I said, to that generation of legal and constitutional theorists to think that courts were tremendously important engines of social change. But it was an outlier. Typically, presidents don't make the kind of damn fool mistake that Eisenhower accused himself of having made with the appointment of Earl Warren. Typically, presidents get pretty much the courts that they want, and typically judges are fairly conservative figures that don't want to rock the boat, that tend to affirm the status quo. And so the court that we've actually had since the Warren Court, first the Burger Court and then the Rehnquist Court and then the Roberts Court, those courts are much more typical of how courts have behaved throughout American history. So if we go back and just to give you a flavor of how courts have tended to behave through most of American history, not the Warren era, Dred Scott versus Stanford was the case in which the court held that blacks were not citizens within the meaning of the Constitution. They're not being contemplated to include them as citizens, and so a fugitive slave did not have standing to go to court to get protection. This is the slaughterhouse cases in 1873. This is in the aftermath. This is the years when the Reconstruction was beginning to fail, and the court did its bit to make sure that it would be reined in. The slaughterhouse cases limited the application of the 14th Amendment's privileges and immunities clause to the federal government and refused to apply it to the states. A case, United States versus Reese in 1876, said that the 15th Amendment, which said that the franchise could not be denied on the basis of race, only denied it on the basis of race. It didn't deny it on the basis of what came to be used for proxies of race, like poll taxes or literacy requirements or the other instruments that were then wheeled out across the American South to disenfranchise blacks. The same year, they adopted U.S. versus Cruikshank, which said that the Bill of Rights does not apply to private actors or state governments, again, limiting the Civil War amendments in their range and force. The civil rights cases the following decade said that the 13th and 14th Amendments didn't apply to private individuals. Lochner versus New York in the early part of this century became emblematic of the court that would strike down much New Deal legislation in subsequent decades, eventually leading to FDR's attempt to pack the court, which blew up in his face as they were striking down so much New Deal legislation. But in fact, the court, even though FDR, he had threatened to appoint 5 new justices and produced a lot of opposition, but after that, the court did back down somewhat. This is the court that, this court in 1944 adopted Korematsu versus the United States, which allowed for the internship of Japanese Americans during the war. 2013, Shelby County versus Holder. This was a decision that cut back on really important parts of the Voting Rights Act, which had required states with a history of suppressing votes or making it difficult for African Americans to get to vote, to have pre-clearance from the Justice Department that there was no longer a problem. And as I think it was Justice Ginsburg said in her dissent, it was a bit like saying we should. We no longer need we can throw away our umbrella, even though the reason we're dry is that we're holding it up. So big reductions on the Voting Rights Act. And then, of course, the topics we're going to be talking about in more depth today, the courts about money and speech, from Buckley to Citizens United, and subsequently. So again, this is just a flavor as well. But the big point here is that these kinds of decisions are much more typical of how constitutional courts have behaved across the range of American history. And so we need to come to terms with that the Warren Court was a remarkable outlier, and it should give us pause in thinking about how important it is to empower courts to behave in the ways that they typically have done. There's a lot of scholarship on this subject. I want to just alert you to some of it. Perhaps the most famous article is one piece by Robert Dahl published in 1957. He was a longtime professor at Yale, and this is a landmark paper in which he shows quantitatively that if you look at the data, there's no evidence that Supreme Court decisions or judicial review has actually contributed anything more to the protection of minorities' or rights or vulnerable people's rights than not having the court there. If this is a book by a professor now at University of Toronto, Ryan Herschel, was a dissertation in this department, where he looks at countries that have gone from not having judicial review to having it. Countries like New Zealand, Israel, and elsewhere, and shows you can't see any significant difference in the protection of individual rights when they go from not having it to having it. Mark Tushnet, a legal scholar, now I believe at Harvard, has written an important book arguing about why giving more and more control over the Constitution is not a good idea from the point of view of protecting the sorts of rights we want protected in a democracy. His Australian counterpart, another legal scholar, Jeremy Waldron, famous article here in the Yale Law Journal. So it's part of an ongoing debate between him and Ronald Dworkin. Dworkin was advocating a Bill of Rights for Britain, and Waldron was saying, don't export this aspect of the American system. And finally, another important book that started out as a PhD dissertation at Yale by Gerald Rosenberg, a professor at Chicago, about Brown versus Board of Education and subsequent decisions, which says that if you look at the real progress that has actually been made in school desegregation, where it's been made, has come from legislatures and not courts. So all of this is just a salutary reminder that we should think about the reality that is not only in American history, but if you look comparatively, the most important variable from the standpoint of protecting individual rights and vulnerable minorities is getting democracy, about which I'll have more to say in coming lectures, and adding judicial review on top of that doesn't do very much, if anything at all. And indeed, sometimes it's inimical to the functioning of democracy and the decisions that are made by democratic legislatures. So, all of that is by way of throat-clearing preamble to our subject for today. And this is Exhibit A, if you like. This is the main message of this lecture. It's Exhibit A in observing that relying on courts as ways of protecting democratic institutions might not be such a great idea. So, where we have to start, because we have a written constitution, a constitutional system, is with the First Amendment, and particularly the speech clause of the First Amendment, which says that Congress shall make no law abridging freedom of speech or of the press or the right of people peaceably to assemble and to petition the government for a redress of grievances. So this is the text which we're all working from. And what I'm going to do now is take you through basically the 40-year history since Buckley versus Valeo of how the court has interpreted the speech clause of the First Amendment as it pertains to money in politics. So the background to this is in 1974, when Congress had enacted very radical changes to the federal election campaign of 1971. They did this over Gerald Ford's veto, and it was the first comprehensive effort by the federal government to regulate campaign contributions and spending. Money was starting to become a really important issue in American politics, and they felt the need to do something about it. I will just note, and pick up this point later, this is the period at which American political parties were starting to become weaker, and I think there's an important connection between weak parties and the need on the part of politicians for money that I'm going to spend more time on later. So the key provisions of the 1974 legislation were to limit contributions to candidates for federal office, limit how much can be given to campaigns. It required the disclosure of political contributions, no secret contributions. It limited expenditures by candidates and associated committees, what we today would call PACs. And it limits independent expenditures to $1,000. And then finally, it put limits on what candidates could spend from their own personal funds in order to get elected. So it was the goal was really to rein in the use of money. And you'll see two terms there that the distinction between which becomes important. The two terms, contributions and expenditures. And they make a distinction between contributions and expenditures, which drives a lot of what they doing. They also provided for public financing of presidential elections. 2 years later, we got Buckley versus Valeo. And Buckley struck down most of that legislation as unconstitutional violation of the speech clause of the First Amendment. It held the following. It said, it's all right for Congress to limit contributions to campaigns, and the argument there was because there's a risk of corruption. If you have people making contributions, they can get a quid pro quo, and that's not cool. But it's not okay to limit expenditures. Here the First Amendment rules. So the idea of an expenditure is if I want to go out and spend money saying I think that Christina should be president, I'm just spending money. I'm not giving her money. I'm expressing my First Amendment views. And that is not, it's not legitimate for Congress to limit expenditures. It's also not legitimate to stop Christina from using her personal funds to get elected because there's no risk of corruption there either. We saw Donald Trump making this argument in the 2016 campaign, saying, I don't need money from special interests. So there's no risk of a quid pro quo. So the argument went. And most important, they said, the idea of leveling the playing field in elections, it might be a desirable thing for governments to do, but it's not that important that it should rise to the level of interfering with the First Amendment, because the First Amendment protects what the court in its interpretive dicta calls a fundamental right. And the fundamental right stands unless there's a compelling government interest. That it's they subject possible violations of fundamental rights to the highest or the most stringent levels of judicial scrutiny. And they said, be nice to level the playing field, but there's no constitutional requirement of a level playing field in elections. There is a constitutional protection of free speech. And so the opinion said the First Amendment simply cannot tolerate any interference with a candidate's freedom to speak without legislative limit on behalf of his own candidacy. This was the phrase about self-funded elections. And then more generally, this is a nice metaphor. This is actually in a footnote to the decision, where the court says, being free to engage in unlimited political expression subject to a ceiling on expenditures is like being free to drive an automobile as far and as often as one desires on a single tank of gasoline. Who is the government to tell me how much gasoline I can put in my car? They might want to level some playing field, but this is about constitutional right protected by the First Amendment. So that was the decision. There's some important assumptions I want to just flag. One is that money is speech. In a dissent, Byron White said money isn't speech, money is money. And money is, he might have also said money is a megaphone, or megaphone for speech. So the second is the one I've already mentioned, that the government interest in leveling the playing, should say, field is not compelling, and so must give way to fundamental rights protected by the Constitution. And the third is that the only corruption worth worrying about is quid pro quo corruption. Of course, we're hearing a lot about quid pro quo corruption at the moment. And unless you can actually show the smoking gun of quid pro quo corruption, I give you something and get something in return, then you can't show, there's nothing to worry about from the standpoint of the corruption of the system. And so that was what was launched in 1976 by the court. Now, This is vastly more important than Citizens United, in the sense that once this decision was made, the changes that have led us down this 40-year path to Citizens United are more or less, nothing's inevitable in politics, but exceedingly likely to follow. I'll just mention a few other decisions that the court made. So in 1990, when the drift to the right on the court was not as far as it has subsequently gone, the court did say that corporations didn't have the same First Amendment rights as individuals. So it was okay for the Michigan legislature to stop corporations from making independent expenditures or to support candidates on the grounds that corporate wealth can unduly influence elections. So they were saying corporations are not protected in the same way, at least, as individuals by the speech clause of the First Amendment. They don't have the same First Amendment rights, and in that case, the government interest in the conduct of elections and leveling the playing field, if you like, not having undue corporate interest trumps. The reason I'm putting the Michigan case there is because that was what was overruled in 2010 in Citizens United. Citizens United was founded by Floyd Brown, a DC political consultant in 1988. And it was an organization, you can see here its leitmotif. It's an organization dedicated to restoring our government to citizens' control. Through a combination of education, advocacy, and grassroots organizations, Citizens United seeks to reassert the traditional American values of limited government, freedom of enterprise, strong families, and national sovereignty and security. Citizens United's goal is to restore the Founding Fathers' vision of a free nation guided by the honesty, common sense, and goodwill of its citizens. It's American as apple pie. And so what was at issue in this case is that they had planned to advertise a film that was essentially an anti-Hillary Clinton commercial shortly before the 2008 Democratic primaries, when she was still running for the nomination. And at that time, federal law had prohibited corporations and unions from making what they called electioneering communications 30 days prior to an election, a primary or 60 days prior to an election, or making any expenditures advocating the election or defeat of a candidate at any time. So there was some limit on the content and some limit on the timing, and the argument had been that under the then prevailing Michigan law, that these were the kinds of constraints that had been legitimate. And in Citizens United, the court said no. The court held instead that Congress cannot limit corporate expenditures, and so overruled its prior decision in the Michigan case, and said the First Amendment rules in the same way with respect to corporate expenditures as it does to individuals. There's no risk of corruption here, so there's no, again, quid pro quo is what counts. And the idea that the court should be involved in protecting the shareholders of corporations cannot stand. By that time, there was a long-established, SOM students here will know, a long-established rule called the business judgment rule, which said that while it's good, perhaps, for corporations to maximize shareholder returns, there's no requirement of that, and the business judgment rule says basically if the shareholders don't like the way a corporation is managing the company, they can either sell their shares, low exit costs, or they can get new management. So it was not the business of the court to protect shareholders from the political uses of corporate money. So the assumptions now are that corporations have the same free speech rights as individuals, and so any government interest in leveling the playing field isn't compelling and so must fall, and again, reaffirming this idea that the only corruption worth worrying about is quid pro quo, getting something in return for giving a politician some money. Now, there's a subsequent couple of decisions that are less often talked about than Citizens United that I just want to mention. So the first one was the same year, Speech Now versus the Federal Election Commission, by the D.C. Circuit Court of Appeals. This is in the wake of Citizens United, where they said contribution limits, whether to independent advocacy groups or cannot be to whether to individuals, advocacy groups, or other organizations cannot be limited. So the idea here is that you can make a contribution to another organization, and that can't be limited. There's no risk of corruption in the First Amendment rule. They said, though, that Congress can require disclosure. So if I'm going to give money to a political action committee or something like that, it's reasonable for Congress to require at least disclosure that people will know where the money came from. The public has an interest in knowing who's speaking about a candidate or making an argument in politics. Again, they're affirming this idea that now become a mantra, that the only corruption worth worrying about is quid pro quo. But the second assumption they made is that this idea of shining light through publicity would be enforceable, that it would be possible to say that corporations could give money to political action committees, and as long as they disclosed it, there was no risk, if you like, to the political system. Certainly not a serious enough risk to justify interfering with their First Amendment rights to make political expenditures as they chose. As I say, good luck with that.
Here to help me make my move to secrecy and obfuscation completely transparent, please welcome former general counsel to the McCain campaign and my personal lawyer, Mr. Trevor Potter. Trevor, nice to see you. You want some? Can I carve you some? You want some ham rove?
I'll wait till later.
No, yeah, well, he's not kosher. All right. Now, Trevor, I've got all these people down at the bottom of the screen who've been giving me money, individual Americans. But I haven't gotten any of the big corporate money. That's why I have a super PAC. Why wouldn't a corporation give money?
Well, they'd be nervous about giving in a way that their name is publicly disclosed. People might object to what they've done, their shareholders, their customers.
Okay, so that's where a C4 comes in. A corporation or an individual can give to a C4 and nobody gets to know that they did it,
That's
right?
right.
Okay, so how do I get one?
And that money can be used for politics.
Oh, great,
So-
that's good too.
So we need to get you one.
As long as it goes through me, it can go to anything at once. So how do I get me one, Trevor?
Well, lawyers often form Delaware corporations, which we call shell corporations, that just sit there until they're needed.
So there's some anonymous shell corporation?
Right, and I happen to have one here in my briefcase.
Let's see it.
So
Okay, what's it called?
it's called Anonymous Shell Corporation.
That's got a real ring to it, Trev.
Registered in Delaware.
Now, I don't have to go to Delaware, do I?
No, it's already been done for you.
Okay. Okay, Anonymous Shell Corporation filed in Delaware. Okay, I got this. So now I have a C4?
Right, now we need to turn it into your shell corporation, your anonymous one, and we do that by having normally a board of directors meeting.
And who's on the board of directors?
Well, just you. We can just
Sounds
have
like a
you
nice
do
group of
this.
people.
So,
All right, let's do it. Let's call it. Okay. Let's. And I've shattered my champagne glass. I hope there's no sensitive electronic equipment down there. All right, call to order. Let's do this thing.
all right. So, this says that you are the sole director of the corporation
I am.
and that you are now electing yourself president, secretary, and treasurer.
Sounds like a great board.
And you are authorizing the corporation to file the papers with the IRS in May 2013.
So I could get money for my C4, use that for political purposes, and nobody knows anything about it till 6 months after the election.
That's right. And even then, they won't know who your donors are.
That's my kind of campaign finance restriction. Okay, so now I've signed it. I have a C4?
You have a C4. It's up and going.
So without this, I am transparent. With this, I am opaque.
That's it.
Without it, you get to know. With it, you go to hell. Without it, here's who gave me my money. With it, you know what? Your mother gave me my money. Well, I like that, Trev. Okay, so now I can get corporate, individual donations of unlimited amount for my C4. What can I do with that money?
Well, that C4 could take out political ads and attack candidates or promote your favorite ones, as long as it's not the principal purpose for spending its money.
No, my principal purpose is an educational entity, right?
There you go.
I want to educate the public that gay people cause earthquakes. Okay.
There are probably some C4s doing that.
Can I take this C4 money and then donate it to my super PAC?
You can.
Well, wait, super PACs are transparent.
Right.
And the C4 is secret. So I can take secret donations of my C4 and give it to my supposedly transparent super PAC.
And it'll say given by your C4.
What is the difference between that and money laundering?
It's hard to say.
Well, Trevor, thank you so much for setting me up in this brave new world. Dismissed. Trevor Potter, everybody.
So he called it right. What we see after a speech now is enter the super PAC. And you have political action committees that can raise and spend unlimited amounts of money from corporations, unions, individuals, and associations. That is from anyone. And so just people who are interested in the details of this, super PACs can choose either to be what had been known as a 527 or a 501c4 organization. So the 527s, these had been created by the IRS to allow organizations and committees to raise and spend money specifically to influence politics. But they had to report donors and contributions. So they accept their donor lists will be made public in exchange for greater freedom to directly influence election initiatives, if you like. The 501c4, as you saw, that's what was being described in the video, works a little differently. It's a nonprofit, just a little different from a 501c3, which is what Yale University is. It was created in 1913 with the intention of creating tax exemptions for civic and commercial organizations that focus exclusively on social welfare. And it can also collect unlimited funds, and here's what they were keying off of. 501c4s do not have to disclose their donor lists. Basically, they forfeit their ability to engage in politics as a primary function, but they gain the ability to keep the sources of their funding anonymous. Somewhere along the line, however, the interpretation of the 501c4 statute started to evolve. First of all, the word exclusively educational came to mean primarily educational. And of course, once you have a word like primarily, you need lawyers to interpret what does primarily mean. And somewhere along the line, and it seems in the 1960s, the agency started to interpret primarily to mean 51%. And It's not clear why. I've done some digging into this. Perhaps there's a lobbying story there, I don't know. But so what it basically means is that you've got to spend 51% on your social welfare purpose, that gay people cause earthquakes, and you can then spend 49% directly on political activity. And this is what gave rise to the Lois Lerner scandal in the Obama administration, which some of you might remember. She was a mid-level operative in the IRS, and they were getting floods and floods of these new 501c4s. This is in the wake of the Tea Party movement. And so she was tasked herself with investigating whether they were doing the 49% or not. And she then got accused of disproportionately investigating conservative 501c4s, and that blew up into something of a scandal that went viral. Well, that was all generated by this law. So in effect, what it's done is it's said that you can engage in unlimited expenditures without disclosure. That slide is misleading. I will fix it before I post it. Well, optional disclosure, I guess is sufficient to say, without disclosure, for 51%, essentially paying a 51% quasi-tax. It's not really even a tax because you can define your social welfare purpose to suit yourself. And so if you want to see what effect this had, this is super PAC spending by disclosure, and you can see that in the 2010 election cycle, before all of this became operative, most of the money was going to companies that, to 527s that were disclosing, and not very much was going to others. But after 2012, you can see a lot more money starting to go to the new 501c4 super PACs, at least half of the spending in that election cycle. So we've seen this is a move into more dark money than we had before operating in politics. The upshot is that contributions to campaigns, to candidates or campaigns, can still be limited by the federal government, but independent expenditures can't be limited, and contributions to organizations that engage in expenditures, right? So contributions to candidates can be limited, but contributions to organizations that engage in expenditures cannot be limited, and reporting rules would require a massive overhaul to be meaningful. So that has been the story of campaign finance reform and the American courts through 2010. I should mention one additional decision, and this is 2014, McCutcheon versus the Federal Election Commission. This is the only subsequent time the court has revisited campaign finance. And there had been a law which had limited the number of candidates that you could give money to. I think it was to 5 candidates in any given election cycle, and the amount you could give to a party was also limited. And so that meant the total amount you could give in any 2-year election cycle came out to $117,200. You couldn't give more than that. And the court said, no, why should you be limited to only giving to 5 candidates? The justification for this combined restriction was unwarranted. It's not tailored to any particular purpose that the government is entitled to engage in. Even though actually Buckley had upheld aggregation limits, they said, again, there's no quid pro quo here. You're not giving money to get anything in return. What's the difference between giving money to 5 candidates and giving money to 30 or 40 candidates? Again, assuming quid pro quo is the only corruption worth worrying about. and massive increase in inequality of contributed power now. Instead of 117,200, you can give 3.5 million in contributions in any election cycle. So again, much more inequality of influence in the world of contributions. Now, some people say this isn't so terrible because it may attract more money into contributions to candidates and less money into dark money. Rick Pildes at the NYU Law School, for example, has made this argument. So the idea is that if you can give more money to the candidates, you won't spend it on dark money, and so we might actually get less darkness. At this point, I think that's speculative. The jury is out. So that is the jot and tittle of the court's involvement in campaign finance reform efforts. Before I turn to the demand side, I just want to say something about the changing media context of all of this, because we're living in a very different world from the world that existed in 1976. Apart from what we make of this equation of money with speech that Byron White and many others have subsequently criticized, in 1976 there were basically 3 TV channels. And because of the scarcity of TV channels, the federal government came up with, this was not done through the courts or even by Congress, it was actually done in the executive branch. They came up with, the FEC came up with something, no, it wasn't the SEC, but it was, I forget exactly which agency came up, but they came up with this Federal Communications Commissions, the FCC, came up with something called the Fairness Doctrine. And the notion there was that because there's a limited number of channels, that if a TV channel puts on one point of view, they must put on a competing point of view from the other side. So there was this notion of achieving some kinds of political balance. And this was never actually challenged in the court, so the court never ruled on it. And we had the Fairness Doctrine until the 1980s during the Reagan administration. And during the Reagan administration, we also had the advent of cable television. And the FCC said, well, now there's an unlimited number of channels, so there's no reason to have the Fairness Doctrine, right? And then we got satellites, so instead of 80 or 90 channels, we have hundreds of channels. So there's no reason to have the Fairness Doctrine, because the logic for the Fairness Doctrine was the scarcity of channels. Now, there's no scarcity. In fact, more or less unlimited number of channels. And so the Reagan administration abandoned the Fairness Doctrine, and that started us on the political consequences of increasingly segmented median markets. The world that we moved to being a world in which people, liberals get their news from MSNBC, conservatives from Fox News or Breitbart, and then, of course, on to the world of social media, the world of people getting news from Facebook, and so on. And so we're now in a world in which it's almost impossible to have any requirement that different points of view confront one another, in the sense that, say, John Stuart Mill talked about in the competition for ideas. The idea that if you think about Prime Minister's questions in the UK Parliament, where the Prime Minister has to stand there and be questioned and defend his or her views to the opposition. We saw earlier Margaret Thatcher defending her views against her Labour critics when she was leaving office. We never have that now, that political speech is not about institutionalized argument over policies. It's rather about mobilizing your own supporters. It's about you speak to the people who already agree with you. We know from Kahneman and Sunstein's research that I referred to last time, that tends to make people more extreme. And so political speech is really about mobilization of people within your world of like-minded people, and not about argument over policy. And that is a development that is underpinned by other changes in the political system that I'm going to get to briefly today, but more fully later on. So let's look for the last few minutes at the demand side. We've been talking this entire lecture about the supply side. We've been talking about why people want to spend money on politics and what kind of influence they think they can get from spending money on politics, whether it corrupts the system or not, what sort of definition of corruption we should have. But why is it that politicians want money? Why do they need so much money? We spend much more money in politics in this country than in almost any other country. Why do politicians need money? Yeah.
Well, they attempt to put out their message. They attempt to buy advertising, lawn signs, things of that nature.
Okay, so they want to put out their message. But, British and German and Dutch and Australian politicians want to put out their messages too, and they don't have so much need for money in politics. So why? Who else? Okay, yeah.
There are no primaries in the UK, and the election cycle takes exactly 6 weeks.
So frequent elections and a staggered cycle, as well as primaries. So we have essentially permanent campaigning, and campaigns are much longer. In most parliamentary systems, you call an election 3 or 4 weeks before the election. There's a very short election cycle. So that's one reason. And of course, if you have primaries, you need money for the primaries. So those are among the reasons people need so much money. Any other reasons? Yeah.
It's seen as a measure of support for the candidate.
Seen as a measure of support for a candidate. So we see, how do you get to be on the stage in the current democratic debates? You've got to not only show that you've risen to a certain level in the polls, but you've also got to have raised money from some specified number of independent contributors. So it's a way of demonstrating that you can get support. Again, it's not obvious why that differentiates American politics from other countries. Yeah.
Well, for presidential elections, this is a huge country, and people need to have teams all over the place, and unlike a parliamentary system where the local elections then govern who comes in power and so forth, here you need to have a completely national campaign, which becomes very, very expensive.
Well, but I mean, that you certainly, many countries you have to have national campaigns, and first and foremost, you have to win in your district, right? In your district. You need the money to win in your district here. But, I think you're onto something nonetheless about thinking about the difference between national campaigning and local campaigning. Is there a hand over here?
I'm thinking about like investments, so like stock market, almost like maybe they're they'll take in the finances and then like invest in bigger corporations and look for those corporations to put their name back out. It's almost, like a partnership.
Well, I think focusing on people investing is also part of it in political investing. Here's a way to think about it, that we have very weak parties in the United States, and I'll say more about what makes a party a weak party. Part of it is primaries, but a weak party is a party that is very decentralized in its control. So in a country with stronger political parties, such as Britain, the party has a big say in who the candidates are going to be. They don't have primaries. As somebody pointed out, we have primaries. So another way of putting it is, in our system, all campaigning has to be retail. It's not, and retail campaigning is much more expensive than wholesale campaigning, because every person is running on their own for their own seat, and they need a lot of money to do that. And they can be threatened in their own individual seat. Some of you probably heard on the news this morning reports that there are some 35 Republicans in the Senate who privately would support convicting Donald Trump if the impeachment resolution goes through the House, but publicly will not. And the reason, and people come out and say it, they say if you did, you would immediately face a primary challenge in your district. And so everybody has to, if you like, in retail campaigning, it's every person for themselves. In wholesale campaigning, you're part of a team that is trying to win as a team. And so in our system, politicians need vast amounts of money because they have to get elected retail. All politics is local, is a famous American aphorism, but that means all politics is retail. So there might be benefits of politics being local, but the cost is that politics is very expensive. And of course, once you have a lot of retail campaigning, it also turns raising money into something like an arms race. Because if you don't raise as much as your opponent, you're not going to be able to have enough money perhaps to get on the debate stage or to get enough media time in order to prevail. And so this is why public funding limits are so inadequate, because what happens is no matter where they're set, people soon discover that they can raise more money if they don't take the public funding. The idea is if you take the public funds, then you've got to limit your fundraising. But the last time the cap was increased was before 2008, and President Obama, who was the first person to use crowdsourced fundraising, realized very quickly that he could raise a lot more money than the limit. I forgot what it was then. It was several $100 million, but his was the first $1 billion presidential campaign. So public funding limits don't work in a world in which people can raise as much private money as possible, and in a world in which you're basically trying to communicate with your base voters. You're trying to communicate to the people who mostly agree with you. And so that's one of the reasons why we find it so difficult to limit the role of money in politics. Some other reasons why there's so much demand for money is that I said to you earlier when I was talking about the resurgent right and the anti-tax movement that a lot of those bodies invested heavily in think tanks because they thought the universities were dominated by the left and be much more efficient to spend the money in places like Heritage, the American Enterprise Institute, and the Cato Institute, and so on. Now, a lot of money, particularly in response to these recent court decisions, is moving from the think tanks. The think tank gap between Republicans and Democratic think tanks has closed somewhat, and the money, it seems, is going into these 501c4s, and that, again, means, from the point of view of the arms race of politics, that your opponents are going to have more money spent on them, and so that you therefore need to get it spent on yourself. And so, again, we find that the remedies sometimes make the problem worse. Just a point about the arms race, I think that this is an area that's actually ripe for reform because politicians hate it. They hate, if you do any interviewing of candidates, you'll see this. Politicians hate it because they have to spend all their time raising money and because they're then controlled by the people who give them the money. And they don't like it. And the structure of an arms race is you can't stop. Underneath it is something called the prisoner's dilemma. Even though it would be in the interest of both of you to stop raising money, if you could agree to do that, the logic of the situation keeps driving people to raise more and more and more money. And so actually politicians, the vast majority of them, would like to get something to stop the arms race, which is why they passed the campaign bill in 1974 that we began with over Gerald Ford's veto. And the reason is that they were trying to put a constraint on the arms race so that they wouldn't have to raise this money. So, but for the court, this problem wouldn't exist. And I think it's, as I said, a salutary reminder of the cost of having independent judiciaries. One final point is that there's been a lot of talk about crowdsourced funding. Maybe this is the antidote. This is the antidote to big money in politics. You know, lots of millions and millions of little contributions. Isn't that great? It's like democracy is in the streets. People can give $1 or $2, and as I said, actually Barack Obama was the first person to use crowdsourced funding in a big way. Bernie Sanders is very effective at crowdsourced funding, and so a lot of people have said, well, so maybe there'll be a technical fix here that we will get to counterweight the role of big money. But what the research shows is that even people who give small amounts tend to not be representative of their districts. They tend to be activists on the fringes of parties. They tend to be people funding groups like the Tea Party or groups on the far left of the Democratic Party. So the idea that you're going to get less extreme views funded, particularly people who give any money outside of their own district, tend to have very extreme views. Almost nobody gives money outside their own district who is not on the extremes of their parties. So the idea that this is going to be a way to sort of restore the influence of the median voter in politics is not something we should get too excited about. On Thursday, we're going to turn to part 2 of the course, and we'll look at democracy's fourth wave, as it emerged in the wake of the Cold War.